a real estate license with a newly issued provisional broker license, C, must be affiliated with a supervising broker in charge to activate that license. All right, you're going to get an inactive license, so you're going to have to affiliate with that broker in charge. In the course of selling a home to a buyer, a broker told the buyer that the home's foundation was solid as a rock, when he knew for a fact that it was slowly sinking into the landfill on which it was built. In this situation, the broker's conduct would best be defined as, this is willful misrepresentation, right? He knew. So, and he said something different. In that particular case, that is willful misrepresentation. Okay. Number 5, licensee's pocket renewal card must be carried by the licensee when conducting real estate brokerage services. All right, you have to have that with you, at least a photo of it. Mm-hmm. Number 6, a real estate agent who is licensed as a provisional broker may be an associate of only the firm that his supervising broker in charge represents. You cannot work for another firm, right? You cannot can't cross over. Can't work for 2 firms. Cross affiliate is what I was looking for. All right, you cannot do that. You can only work for your broker in charge. Number 7, in order to qualify as a broker in charge, a licensee must possess all of the following except, okay? So you need a minimum experience, which is 2 years, that's true. You need an active broker's license, that's true. Do you need a firm license as a broker in charge? No, right? So that's your answer. That's the answer. And you also have to be a requisite character in order to be of no threat. Now, your company needs a firm license, definitely. If you have an LLC, you would need a firm license, but not just to be a broker in charge, not to qualify as a broker in charge. Number 8, a broker cannot legally collect commissions from both the seller and the buyer without D, the prior knowledge and written consent of both the seller and the buyer. Both of them can pay the commission, right? Because the compensation is in your compensation agreements in both the buyer's agency agreement and the listing agreement. So maybe the listing agreement saying I'm only paying a co-broke of 1%. Maybe it cost you as a buyer's agent 3 or 4% to sell the house. Your work was worth X amount of dollars. So you can go back to your buyer and say, okay, if we see this house, they're going to pay me 1, and you're going to have to pay me the other 3 or 4 or 2 or whatever. Okay, they could do that. It's in there. All right, they're going to agree to it right at the beginning. That's why you have to talk about compensation right up front. Number 9, generally, anyone who acts for another person for compensation in matters concerning the sale or lease of real estate must be licensed, except anyone acting under a power of attorney, okay? That power of attorney means that you're working as somebody else. Remember, that's a general agent, right? General agent, or I'm sorry, not general agent, it's a universal agent. Universal agent can act as somebody else if I have guardianship, if I am an executor, if I'm an attorney in fact, working with a power of attorney. I'm representing somebody for their life, right? For their life skills, for their life responsibilities. Not because I'm buying and selling their real estate or multiple, I'm just going to help them do it. So my signature is as good as theirs, right? Number 10, when the license of a broker in charge is suspended or revoked, the provisional brokers under the supervision of that broker in charge must, it is not 2 or 3, it is number 1, find a new employing broker in order to continue practicing brokerage. All right. If you don't have a broker in charge, you can't, as a provisional broker, you cannot continue. You got to go find another one. All right. Number 11, a broker receives an earnest money deposit from a buyer. In accordance with commission rules, the broker deposits the money into a trust account. Had the broker mistakenly deposited the money into the firm's general operating account, the broker could be charged with what's called commingling. Commingling. All right, that means we got their money and our money together. We cannot put our money with theirs. Theirs has to go directly into that trust account, and that's all that can be in that trust account, with the exception of our $100 to keep the account open. Okay. Number 12, under real estate license law, a provisional broker is authorized to act under a broker's supervision. That's it. They can't never sign whether you're a provisional broker or not, never sign a sales contract on behalf of your client. You cannot bind them. All right. You cannot collect a commission directly from the principal. You have to get paid from your broker in charge. And you can't advertise a property solely under your broker's under your name, which would be the broker. You have to do it under your broker in charge's name. So you have to act under broker supervision. Number 13, a non-licensed assistant may do all of the following except they can answer the telephone call, answer the telephone questions concerning basic factual details, schedule listing and showing appointments. Can they complete contract forms for the customers? No, they cannot. All right. And they can show rental properties managed by the employing broker, but they cannot complete contract forms. Number 14, a North Carolina licensee who has paid the yearly renewal fee, but has not completed the required education by June 10th of the previous license year, has the license status of inactive. Inactive. No continuing education, you pay the fee, you're inactive. If you don't pay that fee, regardless of if you have continuing education or not, you're expired. All right? You're expired. How many members compose the North Carolina Real Estate Commission? The answer is 9. 7 by the governor, 1 by the Senate, 1 by the Speaker of the House. 3-year staggered terms. 3 have to be licensees, 2 have to be at large. Okay, the rest can be made up any way we see fit. 16, which of the following statements is true? First one says North Carolina Real Estate Commission can fine a licensees $500 for each violation of license law. They can't fine you. Okay, they can fine timeshares. They can't fine you. A violation of license law or North Carolina Real Estate Commission rules is a criminal offense and may be prosecuted in a court of law. Yes, true, right? Remember, anything that's under General Statutes 93A is a crime, right? It's a crime. So that's our answer. All right. The court may not revoke their license. The Real Estate Commission can, and the Real Estate Commission can fine timeshare developers. Number 17, which of the following is not considered to be a material fact in North Carolina? And it is the sex offender registry, a convicted sex offender residing nearby. We don't have to do anything about that. That's not a material fact, okay? We can point them to the sex offender registry. We can tell them to go to the police department, but we do not have to tell them about a convicted sex offender living nearby, all right? The rest of these, pending foreclosure, change in zoning, structural defect, material facts. Pretty straightforward. Number 18, a licensee must notify the commission of all of the following except, let's see, number 18, right? The answer is B, being charged with a DUI. We are only interested in convictions. If you're charged, then you are, you're still not convicted. You could be acquitted, okay? So the answer here is being charged with a DUI. If you're convicted, that's different. You do have to report it. If you're charged, if you've been arrested or anything else like that, you do not. Only convictions. Which of the following statements is true? And the answer is C. Cash must be deposited immediately, but no later than 3 days following receipt. That is true. All right. Now, let's just go over these others real quick. All right. A bank used for holding trust funds must be physically located in North Carolina. No, they have to be lawfully licensed to do business in North Carolina, but they don't have to be physically located in North Carolina, all right? We can't use credit unions, but any other bank They might not have a branch in there, but they can do business there. A provisional broker may deposit funds into the broker's trust account. Provisional broker may not. All right, gives it to the broker in charge. That's what he does with it, or she does with it immediately. Payments made by methods other than cash must be deposited within 5 days following the receipt. 3 days. 3 days following ratification of the contract if it's other than cash. Okay, otherwise we can get that back. All right, number 20. North Carolina provisional broker may advertise a property only if the broker B uses the only if the broker uses the employing broker's name or the firm's name in the advertisement. Got to use firm's name. That's a blind ad, or well, this is a provisional broker also. So number 21. A North Carolina provisional broker obtained an offer for a property listed with his firm along with a check for earnest money. The provisional broker should immediately turn the check over to your broker in charge. All right, that's the rule. Active real estate brokers are required to do all of the following except, okay, and that is inform the commissions of any changes in broker's office policies. That's up to your broker in charge, all right? You do have to take 8 hours of continuing education. You do have to pay your renewal fee, and you notify any real estate commission of any change in the business name. All right, so you do have to do that. All right, how long is a broker required to retain records related to broker transactions? We all know that by now, 3 years, okay? And that is the answers to your quiz. You have your time on. Any other questions for that? Let's see what number 14 is. North Carolina licensee who has paid the yearly fee and not completed the required education by June 10th of the previous license year has license status of inactive. Okay, it happens. All right, there's your one reading mistake you're allowed, Tyler. That's it, no more. All right, so hopefully you did all right. If you didn't, you know where you stand, right? You got a grade. You got a grade. So these were not too difficult. They're relatively simple. Usually what happens is that when you go back and reread them after you know that you got it wrong, you look at it, and I'm talking to everybody here, you'll look at that question and you say, that was an easy question. Because what happens is this, you got 80 questions on the national portion of the exam, you have 40 questions on the state portion of the exam, or 36 questions on the state portion of the exam. And you come out and your anxiety's up at the beginning of the test. And I'm going to promise that when you make a mistake, a reading mistake, it's going to be on questions 20 to 40. Because you're going to come out like a house of fire and do the first 20 questions, and you're going to say, okay, I got this. And then you're going to back off. You're going to catch a deep breath. And the minute you catch that deep breath, what's going to happen? Your attention is going to wane just a little bit, right? How can I know what the answer is, but how is this going to bite me? Right? Something of that nature. Make it in your head to say every question. So you got to remember, every question number 15, 16, and 17 count as much as question number 77, 78, and 79. They all count. So you got to take them one at a time. Pace yourself through this. Don't burn and then fall asleep. And then all of a sudden, question 60, you say, oh, I still got 20 more to go. All right, let me gear up again. Well, how many mistakes did you make from 20 to 60? Because you didn't pay attention or you misread it. The critical mistakes made in there, the difference between passing and failing. So again, every question is their own exam. Every one of them, all 116 of them. Okay, put it in your head. That's my part of Appendix A. I will answer any questions you have on Tuesday on Appendix A. I want to get moving on to contracts, at least basic contracts for our last half hour here, 40 minutes. Because I'm doing the layout of how the classes are going to go, and we're close. I want to be able to do some review at the end and the night before the class, but right now I need all of that class for classwork. So let's dive into contracts. Let's get started on Chapter 9. This is contracts in general. Chapter 10 is going to give us contracts specific. Okay, so we're going to do these two chapters. So I just put in the chat box the PowerPoints for Chapter 9. And we're going to go from there. We're going to start talking about these contracts. We're going to live by them. Buyer's agency agreements, listing agreements, they're hiring contracts, but still contracts, right? They're not real estate contracts, but they're hiring agreements. Real estate contracts, contracts between two people to do or not do something. Those are all binding, okay? Those are all binding. So we need to be able to understand what's in these contracts, what's in there. Let's talk about basic contract law, all right? So what's a contract? A contract, a legally enforceable promise or set of promises between legally competent parties, supported by legal consideration to do or refrain from doing a legal act that must be performed and for which the law provides a remedy if a breach of promise occurs. Now, so it'll be legally enforceable. We have to have, the parties have to be competent. We have to have legal consideration, valuable consideration, okay? It has to be a legal act. We have to have agreements of two parties, between the two parties. Let's talk about contracts. Contracts can be, hey, you got to do this, or I have to do that. But has anybody ever signed a non-compete? A non-compete contract is saying that, you know, hey, we're going to give you severance pay. In this day and age, everybody's been laid off at least once in their lives, hopefully. I mean, that's life, right? It's no big deal. But most times, sometimes you get severance. I've been laid off, I don't know, a couple of times. All right, no big deal. But in a couple of times, in once, you have to sign every so often, depending on the severance package, they may tell you that you can't compete with that company for a year. And you're going to sign a contract that says, I will accept your money and I won't compete with this company for whatever length of time. So, yeah, so there you go. So you got a non-compete, yeah, and you're limited to how far you can be and all of those things, but they're paying you not to do something. The government does this with farmers all the time. They find a crop, like maybe the crops are in Department of Agriculture, sees that one certain crop is higher than another. Maybe there's an influx of wheat this year or an influx of corn. And if it's costing 8 to 10 cents an ear to bring it to market, and they can't sell it, there's so much glut that they're throwing stuff out and they're not making their money back, the government will pay farmers not to grow that particular crop. Take a year off. Here, we'll pay you for it. Because everybody they'll be throwing stuff out, the market would crash. So again, depends. They do that all the time. So the Department of Agriculture tries to regulate the market, supply and demand, right? We talked about supply and demand a long time ago. So they work it through contracts. Please plant corn instead of soybeans. Here, we'll give you some supplemental money so that you can get started on that. Yeah, I'm signing, right? Okay, no worries. Because I was not going to make any money selling corn or selling soybeans, selling corn, right? So those are the kind of things that we do. We get into contracts not to do something or to change, right? To do some things. You're going to need 4 elements. We need mutual agreement. We have to agree, right? 2 parties have to agree. We have to have we both have to be legally competent. We can't be under a guardianship. If I have a guardian, I can't sign contracts on my own. It has to be the guardian. It has to be a legal act, right? It has to be a legal act. Can't be anything that's illegal. And there has to be valuable consideration, right? Valuable consideration. Money, stocks, inventory, another exchange, whatever, okay? A love and affection is a gift. It's not a contract. So we need those 4 elements, right? We need consideration, all right? It has to be for a legal purpose. We have to agree. We need agreement. And we need the parties to be competent. Those 4 things. That is a valid contract. If we don't have one of those 4 things, we have a void contract. No good. So it has to be voluntary. We can't force anybody to do it, right? Can't do it under duress. We have to have an agreement. or a promise for a promise is really what we're going to talk about, between legally competent parties, supported by legal consideration for a legal act. Express or implied. All right, let's do express or implied. If we have an express contract, that means that it is in words. There's no ambiguity. It's either written or it's explained orally. Okay. Now, all real estate contracts must be in writing. All transfers of an interest in real estate property must be in writing. And an express contract is in words. But we have something called an implied contract. When you went to dinner last night at Ruth's Chris Steakhouse, did you have to sign a contract when you walked in? You don't sign a contract to go sit down, but when they give you the bill at the end of the night, right, you're expected to pay, right? So your actions. If you go to the doctor's office, when you show up, you're expected to pay your copay or pay for any other charges, right? You don't sign a contract then and there, right? You pay your landscaper after he cuts your lawn. That's an implied contract. You didn't have a contract before, you paid him, right? Maybe your landscaper comes every 2 weeks. So those are it's implied. Yeah, you're by your actions. If you pull out a sign on your yard that says, hey, I lost my cat, I'll pay $20 if somebody will bring the cat back. And that little kid comes up to your front door and he's got your cat in your arms and he's knocking on the door. Guess what? You're going to get the cat back, but what's he expecting? He's expecting $20, right? He's expecting $20. So in that particular case, that's not only a unilateral contract, but that's also implied that says that you don't have to do it, but if you do it, I'll give you the money. So there's an implication there. Yeah, so by your actions, not by your words. So the most easy one to remember is when you go to a restaurant. When you go to Walmart, fill that cart through fill of groceries, you don't just walk out the front door and say, I'll pay you later, right? It's implied that you're going to walk through the cash register and they're going to pay for it. That's one. So those are implied contracts. So I want you to think bicycle and unicycle. A bicycle has how many wheels? 2. A unicycle has how many wheels? 1. Has anybody ever seen anybody ride a unicycle? It's not as easy as it looks. What we have here, so when you think about that, we have a bilateral contract. Bilateral contract means we have 2 parties and 2 promises. A real estate contract is a bilateral contract. I promise to bring you the money at the closing on February 25th. You promise to hand me clear title, good title, on that date. 2 promises, buyer and seller, both made a promise to deliver. Now, that is a bilateral. So it says option contracts are unilateral, which we'll talk about later. Susie seller gives Bobby a 6-month option contract during which Susie is obligated to sell to Bobby if she wishes to purchase the property. We're going to get to one a little closer to our hearts when we do chapter 10, and that is due diligence. Due diligence is a unilateral contract. When we do due diligence, we only have one person who is obligated to stay. When we do due diligence, what happens is this. We're buying time. At the beginning of our real estate contract, we are going to buy time from the seller. If we're the buyer, we're going to buy time from the seller to say, I want to do all my inspections. I want to get my financing. I want to do everything that's implied, and we'll cover this in much more detail. But I only have a certain amount of days to do it. And for that privilege, I'll give you $500 or $1,000 or whatever we decide. At any point during that period of time, so let's say it's 15 days. All right. There's no set time frame and there's no set dollar value. So for purposes of this discussion, let's say it's 15 days. I got 15 days to do all this. If at any point during that 15 days, I decide I don't like it, I can leave this deal for anything, for any reason or no reason at all. And I'll get my earnest money back. You'll get the $500 in due diligence money. That's gone. But I can get my earnest money back and I can leave. That means that the buyer has the option during that period to leave and only loses due diligence. Does the seller have the option to leave? No, the seller is obligated. The seller has a promise. He's promised to sell that house. So our unilateral contract is our buyer isn't obligated for the first 15 or 20 days, whatever we said. They can walk away for any reason whatsoever. If they decide that they don't like the house, something wrong with the inspection, anything, they just walk away. They'll lose their due diligence money, but they can walk away and get their earnest money back. All right, and we'll get into this. I just want to use this example for a unilateral contract. However, the seller has no walk away. The seller's stuck. He has, if at any time the buyer comes back and says, all right, let's go forward, the seller's got to go forward. Can't walk away from the contract. So that's a unilateral contract. One promise, all right? One promise. Bilateral, two promises, two parties. So when we're looking at bilateral, right? I promise to pay, I promise to give you the title, I promise to perform. We have one contract with two parts, all right? Seller promises to sell, buyer promises to buy. Everybody's happy. We're all going to meet all of the things that we need to. In a unilateral contract, I promise to sell, you have to perform. Get your inspections and everything else. I bought time, but you can walk away for any reason you want, okay? Seller will sell if the buyer decides to buy. And I just went through what our due diligence is at 10,000 feet, all right? 10,000 feet. I'm willing to bet everybody in here has heard the terms, if they've ever dealt with a real estate agent, after they get the contract signed and all the parties signed it, they are going to say, we have an executed contract on that property. We've all heard it. However, what they have is an executory contract. A contract that has something that remains to be done in it is executory. It is not executed. Executed means that all of the clauses in that contract have been fulfilled and we are closed. Then we have an executed contract, okay? But not until then. Not until then. So even after everybody signed it and dated it and everything else, we have what's called an executory contract. Due diligence, we have to get the, we have to make sure that we get financing. We got to make sure that we get the inspections back. We got to make sure that the bank will, if we have a house to sell, all those things, all those pieces, all have to happen before the closing date, right? So that's executory. Executed is, hey, we closed, we recorded, here's your keys, Mr. Buyer, here's your money, Mr. Seller. Let's all sing Kumbaya. That's executed. But we always call it executed from the signatures. By law, it is not. Let's look at the validity of contracts.
Today, we are going to talk about what makes a contract valid, void, or voidable. Let's start with a valid contract. A valid contract is one that meets the basic elements of contract law. For example, you signed to buy a blue house, the house is blue, the contract is valid. Easy peasy. Next, let's discuss a voidable contract. So let's take that blue house. You signed to get a blue house, and you're very excited about your blue house. But when you show up, lo and behold, the house is a hideous color of green. Oh no. Now what do? Well, you have the option to rescind out of the contract because you agreed for a blue house. The house is now green. But this is not void. This is voidable because you may like that color green and maybe your thing. So you have the option to follow through with that contract. Contracts that have fraud or misrepresentation are also voidable. Also, contracts that are signed under duress. For example, if somebody's holding a gun to your head saying, sign this contract to buy this house, sign this contract, that contract is not void, it is voidable. Now you may be thinking, how is that not void? There's a gun to your head. Well, the fact is, even though there's a gun to your head, you may still want that house. So just because there's a gun to your head, should that take away your opportunity to buy the house? No. What the gun being held to your head does is it gives you the right to rescind. That is why that contract is voidable and not void. A contract that is void lacks one of the four essentials of a contract, which are mutual consent, lawful object, consideration, and capable parties. On your exam, they may ask you, what is the status of the contract if one of the parties is deemed mentally incompetent? Well, the answer there would be void, because it would violate the essential element of capable parties. Till next time, good luck on your exam.
For those of you who are looking for some videos to watch, I like Prep Agent. Prep Agent, just go out to Prep Agent, and he's got a bunch of stuff that could help you. A lot of it is simple like that, and we're going to use a few more as we go through it. But Prep Agent is one of my personal faves. I use it. I actually use it a lot. So if you need something to like reinforce some ideas and things of that nature, go out to Prep Agent. It's PrepAgent, and that's Joe from Prep Agent, and he's actually pretty good. Grab what you can, right? And if it means that you can understand it better there. Now, I don't think he's going to help you with the state stuff, but he will give you a really good national portion of what you need to know. I think he's from California. If we have a valid contract, okay, it's enforceable, all right? A valid contract can be enforced, okay? It has all the essential elements. It's voidable. Now, there are three things that make it voidable. The first one is under duress. You heard Joe talk about having a gun to your head. Okay, if you sign something under duress, it's not void, it's voidable. The second thing is if you are under the influence of alcohol or other, your favorite form of chemistry, all right? If you are not in good mind, it is voidable, not void. And the third one is if you are a minor under the age of 18. If you're under the age of 18, you can void the contract at any time. It's voidable. Duress, intoxication, minor. Okay, those three things. Unenforceable means that we have a contract, but it is not in writing. All right, in real estate, it's unenforceable. What would make a void? Well, we'll talk about that in a second. All right, so unenforceable, it's not in writing. We can have a contract. Let's say Ennis has a house, and I walk up to him and I say, Ennis, I'll give you $300,000 for your house. And Ennis says, okay, that's fine. I said, I'll bring it back to you next Thursday. And he says, great. So I come back next Thursday, I got $290,000. I give it to Ennis. I say, here, give me the title. Ennis says, wait a minute. We said 300,000. I said, no, we said, remember we negotiated a little bit? We said 290. And it says, no. I said, we said 290. He said, no, we said 300. And him and I get in an argument. Are we ever going to have that contract enforced? We don't have anything in writing. And there isn't. The first thing a judge is going to ask you if you go to in front of the magistrate, he's going to say, where's your documentation? And you're going to say, humana. I got none. He's going to pat you on the head and send you on your way. Say, thank you very much. All right, have a nice day. Now, if I come back next Thursday and I give Ennis that $300,000 and he hands me the title to the house, do we have a legitimate house exchange? Sure. We're just going to record that I'm the new owner. We'll talk about that later. But if I do what I say I'm going to do, then we can. But there's no way to enforce it. There's no third party to enforce it. It has to be in writing, okay? There's no such thing as an oral agreement in real estate, okay? Remember with our fixtures, we were talking about in our fixtures, if we talked about it orally and it doesn't get put into the contract, did it ever happen? No, same thing, all right? What we talk about has to be reduced to writing. It has to be reduced to writing. Void contract, on the other hand, says that we're missing something, one of those four initials, right? We'll get on the next page, we'll talk about the four initial terms of a valid contract. If I'm under guardianship, if I am legally incompetent, the state says, Sam, you are no longer allowed to deal with your own money, financial issues, or anything else. You're nuttier than a fruitcake. You may not do this. And I'm going to assign Shamara to be your guardian, and she can do everything for you. And I went out and found Shanta, and I said, Shanta, I like you. I'll sell you my house. Here, give me I don't know, give me $1,000, I'll give you the deed to the house. And let's get into a contract. Can Shamar go in and say, whoa, whoa, he's crazy. He can't do that. And because she's my guardian, my commitment to Shanta would be thrown out, right? Because I cannot get into it. I can't sign my own. I am not competent, okay? I am not competent. As long as I have a guardian and the state has appointed that guardian, I am not competent to handle it. All right, so that is how this works. Okay. We have 4 elements, right, of this valid contract. Mutual agreement, consideration, legally competent, and it has to be for a legal act. Okay, it has to be for a legal act. All right, so let me give you, we need consideration. We need consideration. All right, that's 1. It has to be for a legal purpose. All right, that's 2. We have to have agreement. All right, that's 3. It's got to be what they call mutual assent. All right, and the parties have to be competent. If you can remember that, that'll tell you the 4 different tenets of a valid contract: consideration, legal purpose, agreement, and the parties have to be competent. CLAP, clap. Those are the essential elements. Just an easy way to remember it, right? Clap and we have a contract. A void contract is something that was never enforceable. Hence me getting into a house sale with Shanta. I had no right to get there, right? Never enforceable due to the lack of one or more of the essential elements. Void or voidable, we start getting into the little fuzziness here. A buyer who is voluntarily under the influence when they sign the offer to purchase would render the transaction voidable by the buyer, but not void. What if I was excited about buying it and I went out and I had 3 cocktails too many and I came in and signed the contract? It shouldn't stop me from buying it. You remember Joe saying about buying a greenhouse, right? Maybe now he wants to buy a greenhouse. Maybe the rest is okay. So by being intoxicated doesn't mean that it's void. It just means that it's voidable. If I wake up 3 days from now and I can prove that I was sloshed out of my head when I signed this contract, I can go to court and say, I didn't know what I was signing. Okay, I didn't know what I was signing. Has anybody ever seen the movie Glengarry Glen Ross? He takes a guy across the street and they sit in the bar all night and they drink and he gets them totally polluted and he signs and he buys all of these lots. Next day he comes in and he tries to get his way out of it, and they talk him out. He spent all of his wife's money and everything else. If you can stand the language, I think it at one time set the record for the most F words in a single 90-minute movie, but it is actually a pretty intense movie. It's pretty good, actually. It's called Glengarry Glen Ross. Pretty big play on Broadway, but some pretty good actors in it. Anyway, you can't go out and get your client intoxicated and have them buy a house. Can't do that. Because the next day they can come in and say, I was out of my mind. All right, it's voidable. Now, same thing with underage. Can a 17-year-old buy a house? Grandma just left them about $1 million in cash. Can they buy a house? Sure. Sure he can. Now, no bank is going to lend him any money under the age of 18. But if he comes with a certified check for $500,000 to purchase your house, we can get into a contract. However, if 2 days before the closing, that minor decides that he wants to take 2 years and go see the crown heads of Europe, he's not buying this house. Can he walk away 2 days before the closing? Yes, he can, because it's voidable at any point. Now, 2 things about that. If they turn 18 during the contract period, they can no longer void it. Okay, once they reach that age of consent, they can no longer void it. They're over. And the seller or the other party cannot void it. So the person who is over 18 is obligated regardless. And if the purchaser turns 18 during that period of time, they are obligated. Okay, but until then, do whatever they want. And then the third one in the void or voidable stage would be, hey, look, I was under a lot of pressure. My wife said she'd divorce me. I owed somebody a lot of money. I needed to sell a house. I didn't want to sell it. I found another way to pay him. It was illegal and he wanted the money, whatever. If I was under a lot of pressure to sell it, all right, I could still void the contract if I could prove that that I was under undue stress. Okay.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.